My understanding was that it was...
On Wednesday, the Supreme Court conducted a conferencing of over 20 appeal cases, which were filed before it. Among these appeals was the one involving the Attorney General and Mityana Municipality Member of Parliament Francis Zaake, challenging the Constitutional Court's decision to reinstate him as a commissioner in Parliament. Presiding over the conferencing, Justice Knight Tuhaise ordered all parties to submit written submissions.
That the appellants should file their submissions not later than 14th of March, and we should also file ours by 28th of the same month. There was no clear provision on which they anchored their decision. If you looked at the ruling, or rather the judgment of the Constitutional Court.
In the Constitutional Court, the majority decision ruled that the then Speaker of Parliament, Anita Mong, violated the principles of natural justice by not recusing herself in the matter in which she was a complainant.
We are here to make sure that we get the justice that we need, and we assure that even Ugandans, they are making sure that Parliament is accountable to the people.
Other cases that were conferenced included Professor Zaake Kanyayihamba's appeal, who is challenging the Constitutional Court's decision for dismissing his petition against the removal of bail for suspects in capital offences. Representing himself, Professor Zaake Kanyayihamba informed court that he had already filed his submissions, but the submissions were objected by the Attorney General's office.
That if they are lost in the forest of this court, we shall go and prepare the amendment, and within 2 or 3 days we shall submit the same, because this honorable court had graciously allowed us to submit our submissions.
In her ruling, Justice Knight Tuhaise ordered Professor Zaake Kanyayihamba to file written submissions by March 14th.
The respondent will file and serve written submissions in rejoinder, rather in reply, together with authorities by 28th March 2024. Then the appellant will file and serve written submissions in rejoinder, if any, by 8th April 2024.
The Supreme Court will also reconstruct a new panel to deliver judgment in the case filed by the Attorney General against the former Nakawa Member of Parliament, Michael Kabaziguruka.
Well, in the course of waiting for judgment after making our submissions, unfortunately, we lost 2 justices of the Supreme Court, the Honorable Justice Opiaweri. Our argument is that the stay of execution is supposed to be interim. Secondly, the stay does not affect a declaration of court. So as far as the court system, as far as the Constitution and the law is concerned in this country, there is no court in the court martial.
In this case, the Attorney General is challenging the Constitutional Court's decision when it agreed with Kabaziguruka's petition that court martial has no powers to try civilians. Deborah Namamonde, UBC News.